Hello and welcome to another episode of Workers' Compensation for Employers and Insurance Companies, provided to you from a defense standpoint at BHCS Law, where we like to say, a good claim is a closed claim. Don't forget to like our video and subscribe to our channel. Today is September 2nd, 2022, a beautiful day in San Diego, California. Kids are back in school and summer is almost over. Unfortunately, it's looking a little cloudy for us defense attorneys. I say this because there was a recent panel decision, Elks v. Sharp Healthcare, that rejected the statute of limitations in workers' compensation. Us defense attorneys love to assert a statute of limitations defense. In workers' compensation, any employee has up to 30 days to report a work injury, and generally has up to a year to apply for workers' compensation benefits in the form of filing what's called an application for adjudication of claims. From a defense standpoint, if the employee fails to report any injury within 30 days or fails to file an application for benefits within a year from the date of injury, the statute of limitation runs, and therefore the employer has a defense to deny benefits. In Elks v. Sharp Healthcare, the applicant, or the employee, started developing bilateral wrist symptoms in 2000, and she sought treatment for this. In 2000, she was already being informed of a diagnosis of carpal tunnel syndrome. 9 years later, her treatment consisted of splints and home exercises. Her primary care physician in 2014 hinted at the possibility that her condition may be work-related. In June of 2017, now this is 3 years following her primary care physician's inference of a work-related condition, the applicant, or the employee, completed her employer's accident reporting and treatment form and alleged an industrial injury to her bilateral wrists and hands. Reasonably so, the employer asserted a statute of limitations defense pursuant to Labor Code Section 5400, which indicates that an employee must report any injury within 30 days. In the Elks case, the primary care physician inferred that the applicant may have a work-related injury, and this was stated in 2014. Now, the employee waited until 2017 to report an injury. That's well over 30 days. Not surprisingly, the claim was denied and thereafter litigated. Unfortunately, the Workers' Compensation Judge and the Workers' Compensation Appeals Board rejected the statute of limitations defense and any argument based on Labor Code Section 5400. The Workers' Compensation Appeals Board opined that the defendant, or the employer, failed to show it was misled or prejudiced by such failure to report the claim within 30 days of knowledge as required by Section 5403. From a defense standpoint, an employer can be prejudiced if an employee fails to report an injury within 30 days. If in fact there is an injury and the employee continues to work, the employee's condition presumably gets worse and therefore increases the probability of permanent disability and further an increase of need for future medical care. This, of course, depends on the nature of the injury. On the other hand, if an injury is timely reported, the employer can afford medical treatment and the employee can undergo conservative treatment and potentially have all of its symptoms resolved. Further, failure to timely report an injury deprives the employer of its ability to investigate a claim and ability to make an informed decision as to whether it should accept or deny an injury. The Workers' Compensation Appeals Board in this case relied on Labor Code Section 5412, which states, the date of injury in cases of occupational diseases or cumulative injuries is the date upon which the employee first suffered disability therefrom and either knew or in the exercise of reasonable diligence should have known that such disability was caused by his present or prior employment. In this case, in the Elks case, The Workers' Compensation Appeals Board did not rely on the 2014 date, simply because the applicant did not miss any time off work, or the applicant did not sustain any period of temporary disability. Because of this, defendants could not use the 2014 date as the date of injury in order to trigger the requirement to report an injury within 30 days. Therefore, the Workers' Compensation Appeals Board again rejected the statute of limitations defense and found that the applicant had the right to file an application for benefits and enjoy the protections found in the Labor Code. If you spot a statute of limitations defense, make sure you conduct proper investigation. You'll need to look for past employment history and determine if the worker had any temporary disability or any past work restrictions during the period in question. You can always refer the claim to a defense attorney who can subpoena records or conduct a deposition to further investigate the claim. The key takeaway from the Elks case is that issuing a denial based on a statute of limitations defense may not be enough. It's very likely that further discovery and litigation may be necessary.
This video is to provide general information regarding the workers' compensation system based on the opinions of the attorneys at Babcock, Holloway, Caldwell & Stiers, Alaska and California offices. This video is not legal advice and is not intended to create an attorney-client relationship. If you would like personalized or case-specific legal advice, please contact Babcock, Holloway, Caldwell & Stiers at defendwcclaims@bhcslaw.com.